Good afternoon, everyone. Thank you so much for being here at the Frank M. Johnson Federal Courthouse. We are thrilled to have the Judicial College participants and teachers and observers here with us. I was going through preparing just some welcoming remarks, and I wanted to go through and make sure that I especially recognize the very important VIPs that we have with us, and I realized I was going to essentially be calling the roll. You're all VIPs, and I don't think calling the roll is a good use of our time, so you are all very honored guests, and we're thrilled to have you here. I know that you did not come to hear me speak, so I'm just going to point out we are really, really fortunate to have with us Judge Joe Flatt from the 11th Circuit Court of Appeals, who will be giving us a wonderful presentation in a little while. And then certainly in a few minutes, you're going to hear from our own Judge Myron Thompson, who is going to give you some really interesting and just an incredible history of this court, and in particular this courtroom where you are sitting. You are in a very historic courtroom, so please do take a moment and just sort of take it in and admire not just the spirit of what happened here, but the wonderful facilities that we have here as well. And so I just want to welcome all of you, and I'm going to now pass the microphone to former Chief Justice of the Alabama Supreme Court, Sue Bell Cobb. Thank you so much again for being here.
Thank you, Judge Marks. Isn't she great? I'm so proud to have the honor to be with all of you today, but I want to recognize one of my successors, Chief Justice Parker. Please, Chief Justice Parker, stand up. I want to make sure everybody sees you. And there are many other people here, but I want y'all to know, and I know we've got Leadership Alabama folks here, right, is that this is the first time in the history of the National Judicial College that they have chosen the state of Alabama to host a course. And it's entitled The Threat When Justice Fails, the Threat to the Independence of the Judiciary. So we have 43 wonderful judges, including a justice from Guam, my good friend Robert Torres, they're here, 43 judges from all over the nation here in Alabama. Many of them, some of them for the first time, many of them the first time in many, many years. We also are honored to have the president of the National Judicial College, Bennis Aldano, and we're so honored, and our provost, to be here with us. But I'm here today to tell you that it is truly an honor for me to be able to introduce one of my dear friends, a little girl from Evergreen, Alabama, and a little boy from Tuskegee. We didn't do so bad, did we? Yeah. So growing up in a small town in Tuskegee, myself growing up in Evergreen, Alabama, I didn't make it to Yale, but he did, undergrad and graduate law school. And in 1980, one of the most wonderful things happened for the state of Alabama. He was nominated by President Jimmy Carter to be a district judge in the Middle District of Alabama, where he has served with such tremendous integrity. He would be embarrassed if I listed all the awards that he has received. The Yale Achievement Award, from Stanford, I mean, name it, he has won it. And there's a reason why. He deserved it. He was instrumental when he was chief judge in making sure that the bus station was preserved, and he has been such a leader in the state of Alabama. But one of the things that he's managed to be such a source of encouragement to so many of us, right, Judge Watkins? So when one of your fellow judges says, you got Judge Thompson speaking, he's a rock star, he's got to be pretty good, right? So I just want to tell you, to every single one, Trey, everybody, Judge Marks and Judge Watkins and everyone, we really do appreciate this opportunity to be in this historic place and to welcome these wonderful judges. And if you will, if you're a judge attending the course, if y'all will please stand. I'd like for all the judges to please stand. They're from the state of Washington to California to New York, Pennsylvania, Florida, Guam, all over. Y'all, would y'all please greet them for us? Thank y'all. Thank y'all so much for being here. So much. Judge Thompson, take it away.
Oh, my goodness. Thank you very much. Oh, I need the mic. I'm adjusting my pants here. One of the judges here said that my shirt button was open, and I love it that you can feel so comfortable. One judge can say that to another judge, right? So I was sitting up there adjusting it. But I'd really like to welcome you here this afternoon. It is a pleasure to talk to you judges from all over this country. And I'm humbled talking to you as a federal judge, actually, because I know that many, if not most of you, are state judges. And as a federal judge, I enjoy what's called that life tenure and the salary that can't be reduced. And I know that you state judges don't have that. And when I was in law school and we were sitting out on the sort of the steps of where I and my roommates were sitting out on the steps, and we were talking about what we wanted to do when we got out of law school. And they all said, well, I'd like to, go work for, the Legal Defense Fund. I'd like to go do some other sort of public pro bono work. And apparently, according to them, and I do not remember this, I said I wanted to be a federal judge. And someone said, why? And I said, it's great tenure. Mine was not an idea about doing justice and rendering important opinions. Mine was the tenure thing. So I don't remember that comment, but they swear that I think I said it jokingly. Well, I guess I said it jokingly. But again, I'd like to welcome you here, and I do speak humbly because you have to be so courageous to do what you do, you don't have that luxury of not having to run for office or not having to be reappointed every so often or elected every so often. And I look up to you, and I think of just the courage of what you do day in and day out. And I also look at resources. I think probably the most important, after the tenure thing, that judges have to have is resources. And we federal judges, to be candid with you, have a lot of resources. We get computers and law clerks and all that. And I know the state judges really struggle with that. And again, I say you have to still do what we do, but it's sort of like like Ginger Rogers says, she has to do everything Fred Astaire but backwards. You have to do everything we do, but with less. And I know that is a challenge. But I'd like to start my remarks by talking about this courtroom. You are literally sitting in a historic place. Dr. King would have been here and sat in one of these seats. Rosa Parks regularly came here, and she would have sat in these seats. And many of the people who stood up against discrimination and Jim Crow laws, many of whom are black, sat in these seats where you're sitting now. And that is what's so wonderful about this courtroom, is that these people came here for justice. And what's even more wonderful about this courtroom is that they got it. And but there's an irony in this courtroom. And you know what the irony is? Hanging above you is a balcony that was built in the 30s, where if you were my color, you would have sat up there. You would have been relegated up there. So every day I enter this courtroom, I have to look at that balcony as a reminder of where my parents would have been required to sit, my grandparents would have been required to sit, and everyone, my relatives, and everyone who looked like me would have been required to sit in that balcony when it was built. I sort of inquired as to whether that was true in federal installations, and it was. When I first was appointed a judge, I said to myself, someone asked me, says, what do you think about the balcony? And I said, I'd love to tear it down, because it reminds me of the indignity of discrimination. And I thought, I don't need that reminder. Why should I enter my own courtroom and be reminded that I'm inferior? But then I came to recognize, and you probably, as you go to the museums tomorrow and you look at other places here in Montgomery, and you ask yourself, what's the purpose of preserving these things? That balcony, I think, serves an important purpose. It reminds me of where I came from, and it also reminds me that there are many people in our society who live in figurative balconies. Maybe not literal ones, but figurative ones. And so I think now if someone were to try to take down that balcony, I would fight them tooth and nail, because I think it's important to remember the irony in this courtroom that it has a balcony built back 100 years ago, but it also stands as a place of justice. And the two together, I think, it's that irony that I think gives life to visiting in this courtroom. It gives life when you think about buildings and what they mean. It also reminds us that buildings themselves don't really mean anything. It's the people who occupy them. It's the judge who sits up there that makes the difference. So you can have a balcony that symbolizes segregation, and yet you can have a judge who literally changed this society, all in the same room. And of course, I'm talking about a judge who I've been asked to talk to you about, called Frank Johnson. And I'd like to discuss Frank Johnson with you because he is a rare person for me. He literally has occupied, in one way or another, most of my life. I grew up in Tuskegee, Alabama, and I know you all are from all over the country. And it's about 40 miles from here, and east of here. And I grew up in a college town, Tuskegee Institute. And of course, many of you know it was founded by Booker T. Washington, and it has all of this black history. And when I was growing up there, I grew up in a totally black environment. Everybody I saw was black. I virtually had no contact with white people until I went to college. But the black people I had contact with tended to be well educated because they were connected either with the college, and back then they had a black veterans hospital there as well. And so it had a sort of a cadre of very educated blacks in the community. But what it didn't have in large number was white people. Not until I went to Yale to college did I actually have any contact with white people at all. But what the point of that is that you had all of these black people, and you had doctors and lawyers and educators, highly well trained. But one thing they could not do was vote. One thing they could not do was go to a fountain and drink out of the same fountain as white people. Growing up in Tuskegee, when we would come to Montgomery, where you're visiting right now, I drank out of a colored water fountain. I remember it vividly. And by the way, the water is not colored. But I drank out of a colored water fountain. I sat down in the basement of the Crest building where my mother would take me to get a sandwich, which was for black people. I remember being really afraid to come to Montgomery because when I was 10 years old, I read in Jet magazine what had happened in Mississippi to a young boy from Chicago who was severely beaten. And we were the same age. And what happened to him in Mississippi could just as well have happened to me in Montgomery. So that was the environment that I lived in. Even though it was an educated environment, I was still no better than, I'd have to say it, the least educated white person. In fact, when I was growing up, you could not even be able to read and write and you could vote in Tuskegee. You could have a PhD and you could not vote in Tuskegee. I mean, you were literally under, as far as recognition of your accomplishments, of the least educated white person. Now, where does Frank Johnson come into this? The first time I heard about Frank Johnson was that because Tuskegee had no political power, the people of Tuskegee redrew the map of Tuskegee. They gerrymandered every black person out of the city, except for maybe less than 5. They even went down streets to gerrymander it, and they would pick up a house here that was white, exclude a house here that was black. I mean, it was that detailed a gerrymander. And that case was presented here to Frank Johnson. You know, years later, after I became a judge, and I was researching that case, and it's called Gamillion versus Lightfoot, And it was literally a case that Judge Johnson handled right after he was appointed. It ended up that my own stepfather was a plaintiff, and I didn't know it. And he died, and I never asked him about it because I didn't even know he was a plaintiff in the case. But anyway, to get back to the case itself, it was filed here right after Judge Johnson was appointed. Judge Johnson threw it out. And he threw it out because he thought he had no jurisdiction. That is, he thought it was a non-justiciable case. It was a political question. It went up to the Fifth Circuit. The Fifth Circuit upheld him 2-1, but Judge Brown, who was on the Fifth Circuit back then, dissented. The case eventually goes to the Supreme Court, and the Supreme Court says the case can be heard. And it came back down to Judge Johnson, and he enforced it with rigor. Not only did he enforce it with rigor, he then, I think the fact that he got reversed made him even more sensitive to the conditions that existed in this society. That is, he realized that he had a Supreme Court that was willing to back the vindication of the rights of black people in the state of Alabama. And Tuskegee, where I grew up, was, of course, the winner in that case. And there were two people in Tuskegee whose names we used to say were almost mentioned with reverence. One was Dr. King. When I was growing up and we would be sitting around the family table, and someone would say, you know, Martin Luther King. They didn't say Martin Luther King. They said Dr. Martin Luther King. I mean, he was a man that you respected. He was bigger than life. And the only other person we talked about like that when I was growing up at the dinner table was Frank Johnson. You didn't say Frank Johnson. You said Judge Frank Johnson. You said the whole name because he demanded that respect among black people. Eventually, of course, and I'm going to talk about some of his cases in a few minutes, but I wanted to give you sort of the ambience and the context in which I grew to know him as a child. And I'm talking about as a 10-year-old, an 11-year-old, and a 12-year-old. I first learned about Frank Johnson, and I first grew to respect him when I was 8, 9, 10 years old. How many 8, 9, and 10-year-olds know who judges are? But I did. And all of my friends did. Because we, as 8, 9, and 10-year-olds, we talked about Frank Johnson, Judge Johnson. And of course, he desegregated the schools in my community, Macon County. And we talked about it. And we knew that if there was one white person in this entire state before whom we could find justice, he was it. And we knew it as 10-year-olds. Now, eventually, I went off to school, and I came back down here to practice law. And I'll be honest with you, one of the reasons I came back was to practice in this courtroom. And I remember sitting right where you're sitting as a lawyer, as a trial lawyer. And he would sit on the bench, of course. And of course, all lawyers who sat in this courtroom who appeared before Judge Johnson appeared with trepidation because he was a very austere. Some people even find, well, he was intimidating. And some people thought that because he was so intimidating, he was probably not a very warm or friendly person. Now, I'm going to tell you in a minute that's not true. He was extremely warm. But when you were in his courtroom, he may not be warm. But one thing you got was justice. And it didn't matter what color you were. It didn't matter what sex you were. It didn't matter how much money you had. You just got pure, unadulterated justice. And it came at you in an austere way, in a fair way, but you knew you got justice. And as a lawyer, I remember, I want to tell you about two cases that I had literally in this courtroom. The first case was one involving a defendant who had refused to plead guilty before Judge Johnson the day before trial. And I had been practicing law maybe a month or two. And the lawyer who was representing the defendant moved to withdraw because the relationship had deteriorated to the point that the lawyer felt that he could no longer represent the defendant. And Judge Johnson allowed him to withdraw. And he also said, well, if you don't want to plead guilty, we'll go to trial the next day. He calls me up on the phone, and he says, you, Myron, Mr. Thompson, you're appointed to represent the defendant. And I said, when do we go to trial? He said, tomorrow. This was when judges could do that. You appointed a lawyer on day one, you went to trial on day two. Anyway, those were the old days. Anyway, so we go to trial, getting ready to go to trial. And I call him up, and I call up Judge Johnson. I say, you sure we're going to trial? He said, yep, you're going to go to trial tomorrow. If it's a problem, it's your client's fault. So I go to my client, and I say to him, tell me what happened. And if I remember correctly, he had been caught with drugs on a federal installation. That's why it was in federal court. And he said there was this John, and he couldn't remember his last name, who could verify that he was innocent. How many of you who've been trial lawyers know that that definitely means he's guilty? If he can't even tell you the guy who can claim he's innocent, can't even tell you his last name. And I'd been practicing 2 months, and I knew that that was one of those cases where my client was probably pulling the wool over my eyes. So I listen, and I say, okay, you tell me about it, and he proceeds to tell me about it. And I guess maybe you could say I was silly enough, or uneducated enough, or lacking in the ability to tell my client no. I filed a motion before Judge Johnson to subpoena John. And I brought it to his chambers. And he said, all you know is John? I said, yes. And I said, I can tell you this. He works out at the military base, and my client says he's left now, but he thinks he was a military officer out there, a law enforcement officer out there. But that's all he knows. And he signed the paper to subpoena John. And he not only did that, he ordered the FBI to find him. True, he not only signed the subpoena, he said the FBI will find John. I go back home. By the way, I'm living in Dothan, Alabama, which is about 2 hours from here. At midnight, I receive a call from the FBI saying, we found John. I then called John, and John was a military officer and verified that my client was innocent. The FBI gave him an airline ticket so he could be here the next day before trial. Of course, not trusting that John might change his story, I go out there with a tape recorder before the U.S. attorney can get to him and record that he says my client is innocent. I take it to the U.S. attorney, and they drop the charges. That's Frank Johnson. No matter who you are, no matter how poor you are, no matter how insignificant you are, he was willing to put the forces of the FBI behind the littlest man, just like the FBI can be put behind the most powerful in our country. That is a true story. So in other words, you were never too small for him. The second story I'm going to tell you about was I represented schools in the desegregation of schools here in Alabama. I represented the plaintiffs in the desegregation of schools here in Alabama. And I represented the plaintiffs who were suing the city of Dothan. And we were, litigating the issue of desegregating the schools, the assignment of students, and so forth. And it ended up that the white students refused to go to school in the black neighborhoods because there was a pollution plant in the area. My grandfather lived in Dothan, and but for Tuskegee, I had grown up in Dothan as well. And I knew about that pollution plant. And I remembered growing up, you would go down there, especially in the summertime, and the pollution was so bad, there was this sort of white dust all over the black neighborhood. I mean, you could literally just wipe it off of yourself if you were out in the air that long, especially in the mornings. You could wipe it off of cars. And there was no question that if that plant had been in a non-black neighborhood, it would not have been tolerated. So I and the Justice Department filed a motion in Frank Johnson's court saying that this plant was impeding the desegregation of the school system. And we did not know how he would respond to that. He issued a show cause order to the plant as to why they should not be held in contempt for impeding this desegregation of the Dothan school system. The plant hired these big-time lawyers. They talked to me and the Justice Department lawyers, and we went to work on it. And they put scrubbers on that plant. They got rid of the pollution. And finally, Judge Johnson set it down for a hearing. And we walked in to tell him that we had resolved the issue, that the plant had resolved the issue of pollution in the black neighborhood. And as I was walking out of the room, after he had agreed to the dismissal of the case, that aspect of the case, he stopped me and he said, "Myron, did you solve your pollution problem?" I said, "Yes, it's good, because you know you had no claim otherwise." True. But that was the type of man he was. He knew about that pollution in the black neighborhood. He knew that it was unfair. But he was willing to do the right thing. And he knew that the lawyers for that pollution plant, if there was anybody they did not want to tangle with, was Frank Johnson. And he took advantage of it. So that was what it was like to practice in this courtroom. The other thing was, I remember I had a friend who came up here to argue a case. And you were so intimidated by appearing in this court. And this friend of mine, and this is actually before I'd actually appeared before him myself, was standing right here, approached the podium, and just fell right over. Just fainted. Just the idea of being in here was too much for him. And it was, of course we heard this. And also when I was in Dothan, one of the things I would always do, after I had practiced here a number of years, of course I didn't practice law but 6 years since I was appointed when I was so young, I would remove cases to federal court. And one of the things I did that for was because I knew I could settle a case if I got it in federal court. Because to be candid with you, the state court judges were not receptive to certain claims. And that's because, as you all know, they had to be elected and maybe they were raised in an environment. But I knew in this court it made no difference who you were, and you always got justice. Also, it was like throwing me in the briar patch. I knew that here I was comfortable. I was where I wanted to be. They were where they did not want to be. Now I want to talk about I'm watching the clock here. I want to talk about some of Frank Johnson's cases. The cases are just monumental in their, each one is virtually monumental. The one I know the best is Wyatt versus Stickney. I actually inherited that case from Judge Johnson. And that case has an interesting history to it. It was literally filed by the workers in the mental health system here in the state of Alabama. And as the Fifth Circuit described the case when it later affirmed Judge Johnson, it sort of magically turned into a case brought by the patients. And what Judge Johnson did was to recognize how the state of Alabama was treating these patients in the mental hospitals of Alabama. And he goes to describe, he was a great trial judge because his descriptions of conditions were just so moving. That's, you read his opinions and you can just see it. It's like reading a novel or watching a good movie. It just captures you. And he talks about how these mental health patients were warehoused and how hoses were used on them. These are people in mental hospitals. Hoses were used on them to control them. How they weren't fed. How there was one toilet for many hundreds of people sometimes, just one toilet. How some of them were just put in hallways. How some of them were just totally, essentially just kept in a condition through medication where they didn't know where they were. And of course, many of them just didn't know where they were. And he describes this. And he enters certain standards, and they're now called the Wyatt standards. And it goes through, it's the standards set out basically when you can put someone in a mental institution, what you have to show, what type of treatment you're supposed to give to them. And this is basically for not only the mentally disabled, but also for the mentally ill. It was both, and there are different standards for each. Back then we called it the retarded rather than the mentally disabled. And these standards, which had basically never been set before, if you go to any state in this union, you will find standards now written into the statutes that are comparable to the standards that were articulated and set in this very courtroom by Judge Johnson, called the Wyatt Standards. I recently went to Argentina to a conference on international human rights. And you could talk to people about the Wyatt Standards, whether you were from India, whether you were from, Pakistan, whether you were from South Africa, whether you were from Argentina, whether you were from London, England. Everybody knew about the Wyatt Standards. They became international standards for the treatment of the mentally ill. And in fact, when I later inherited this case and I dismissed it, I terminated the litigation, one of the things I said about the case was, this is what's so remarkable about this case. I can terminate the case, but I can't terminate what it did, because it's literally written into the law of the whole world. It's literally written into the law. Actually, those standards are articulated in Alabama's own laws. They just adopted the Wyatt Standards. So I can terminate the case, but I can't terminate what it did. Isn't that a remarkable piece of judicial action? And it's just mind-boggling. And then, of course, not only did he wrestle with the conditions of the mentally ill, he wrestled with the conditions of prisoners, about the conditions in the state prisons involving overcrowding and violence. He wrestled with the conditions in the prisons involving the treatment of the mentally ill. Those issues are back before me, but he set the standards even of those back then. When it came to the treatment of the right to vote, and I told you about Gomillion versus Lightfoot, which I was so concerned about because it affected my community, Tuskegee, so directly. He rendered many decisions that vindicated the rights of blacks to vote. When I was growing up, of all these rights we're talking about, for me, the right to vote was just so basic, only because that's all my parents ever talked about. To me, it was the right above all other rights. If you can't participate in your democracy, then you don't participate at all. So the right to vote is just so fundamental. And that's why I thought that what he did in that area, and I think he recognized it as such, I thought what he did in that area was so important. But along those same lines, it was Judge Johnson, and I don't know how many of you know this, who authorized the Selma to Montgomery March. He was the judge that said that Dr. King could march from Selma to Montgomery. You remember at the Edmund Pettus Bridge, Dr. King and the other marchers were brutally beaten? They came to federal court to do something about all the violence of the state of Alabama. And it was in this court where you are sitting now that the case was heard, and I think it took about a week. And Judge Johnson entered an opinion, and it's a wonderful opinion. Because, you know, one of the things about Judge Johnson was he and Dr. King were not always on the same wavelength. Judge Johnson sort of thought that issues should be resolved in court, and as he put it, not in the streets. So he was sort of ambivalent about this notion of going into the streets. He thought if you had a grievance, you should resolve it in court in a peaceful way. Of course, Dr. King believed that the courts often were just too slow, or that you needed more political power to achieve certain ends, and we'll talk about that in a minute. But he filed this lawsuit before Judge Johnson, and I don't think you could be terribly certain that Judge Johnson was going to allow Dr. King to make that march, especially since he knew that the Klansmen were out, and he was aware that these blacks could literally be slaughtered. And he was definitely concerned for that reason that you should resolve it peacefully in court rather than in the streets. And even though it was peaceful, it could still result in violence. But he wrote this wonderful opinion where he talks about how the denial of the right to vote to these black citizens of Alabama had been so long-lasting and was so important that the right of these black citizens and those who supported them to march in protest outweighed any concerns you might otherwise have. So what he did was he set restrictions on the right to vote. In other words, he made sure that the highway was accessible so it could be on one side of the highway. He said that only a certain number of blacks could march. But what he did recognize was the importance of that right and how that right overrode any other concerns. In other words, he said, we will set up a structure that will assure their safety. And of course, what he did was call on the federal government to make sure that this march was peaceful and to assure that these people who were marching were safe. And that's how you got the Selma to Montgomery March. And of course, Dr. King eventually gets here in Montgomery, and then you have thousands of people who then converge. But the march was done. It happened. And it happened because of what happened in this courtroom. And eventually it led to the passage of the Voting Rights Act, as I'm sure anyone who studied the history of the Voting Rights Act. It happened because of what happened here. I'm trying to remember, there's so many cases that I could talk about. The other case involving voting rights was one that actually I sat with Judge Johnson on. When I was first appointed to the bench, I sat on a 3-judge court with him, and I think I must have been about 35, 34 years old at the time. When I was appointed, I was 33 years old. I was the youngest judge and federal judge in the country, and looking back on it, I think I was too young too. Don't worry about it. But anyway, so I'm sitting on this 3-judge court, and of course I'm sitting with this man who's from the age of 8. I literally thought walked on water, and we had just heard a case, fairly straightforward Section 5 case of the Voting Rights Act, and I'm sitting with him and another judge who was known as Judge Hobbs, who's sort of patrician white judge here, highly well respected. And back then, Judge, if you were the youngest judge, you spoke first, because that meant that you weren't intimidated by the older judges. And let me tell you, it was good I spoke first, because I would have been intimidated by those other 2 judges. And so I brought forward this, this 100-page memo about why I thought we should rule for the plaintiffs. And I got through about, in our discussions, I got through about 20 seconds of it. And Judge Johnson turns to me and he says, well, Myron, what do you think is a fair thing to do? And I said, I think we should rule for the plaintiffs. And then he says to Truman, what do you think? He says, the plaintiffs. And then he turns back to me and he says, Myron, write us an opinion and keep it real, real short. So he was just a remarkable person. I also remember that early on, I had a case involving the use of deadly force. And I had ruled for the plaintiffs in this case. In fact, it granted summary judgment to the plaintiffs. And the case had gone up to the then 11th Circuit. The 5th Circuit had become the 11th Circuit. And no other court, at the time I made this ruling, had found this about when deadly force could be used. And I met Judge Johnson in the hallway. And he said, "You're sweating bullets, aren't you?" And I said, "Yes, I'm sweating bullets." And he said, "Well, do you think what you did was right?" And I said, "Yes." And he said, "I think what you did was right, too." And he said, "But you're still sweating." I said, "Yes." He says, "That's why you have life tenure. It's so you can do the right thing. And if you have a backbone," and you do have a backbone, don't you? "Then you don't have nothing to worry about." And that was so encouraging for a young judge to hear that, you know, that was his principle, though. And, but he was that kind of man who realized what it was like, because he was 37 when he was appointed, so he knew what I was going through, and he knew that I was sweating bullets. And it was so wonderful to have a friend like that who could be there when I was sweating bullets and I was so unsure of myself. And that's when, you realize just the importance of that judicial independence that we federal judges enjoy. And I guess the word truly is enjoy for you state judges. It is something. The other thing I want to talk to you about is another case when we talk about judicial independence in the civil rights era, which is a case involving Rosa Parks. Well, right after Rosa Parks had been arrested, the Montgomery boycott had occurred, a lawsuit was filed in this court. It's amazing how many lawsuits went through this court. In this court, Browder versus Gale, involving the desegregation of public transportation. And it was a 3-judge court. It was Judge Johnson, Judge Reeves, and a judge from Birmingham. And Judge Lynn, I think it was. Is that right? Yeah. Judge Lynn from Birmingham. I want to tell you a little story about Judge Reeves first. Whenever I have this opportunity, I love to talk about Judge Reeves, because next to Judge Johnson, and when I say next to, I don't mean after, I mean right next to him, was Judge Reeves. And Judge Reeves was different from Judge Johnson because Judge Reeves was born in Montgomery, Alabama. He was part of the Montgomery, I could almost say aristocracy. Judge Johnson had come from a county, Winston County, and he was considered an outsider coming into Montgomery. But Judge Reeves was here. And when we're talking about judicial independence, it comes with a price. And I think Judge Reeves, in many ways, symbolizes that price. He stood shoulder to shoulder with Judge Johnson in all of those opinions here in Montgomery. Judge Reeves did. And he was ostracized in this city. I mean, people had nothing to do with him. When his son died, people threw trash on his son's grave. That's Judge Reeves. When I was appointed a federal judge, Judge Godbold, who had then become chief judge of the circuit, invited me to have lunch with him and Judge Reeves. At this time, Judge Reeves, I guess it was in his 80s. And I went to lunch with him, and eventually Judge Godbold took on another job at the Judicial Center, Federal Judicial Center, and I went to lunch with Judge Reeves by myself. And for 2 years, I took Judge Reeves to lunch, and we would meet upstairs in his office. His wife would bring him down here. He wasn't hearing cases anymore, and the only reason he came down here was to have lunch. I would meet him for lunch. He could barely, he was sort of, I was so afraid he was going to fall whenever he walked. And we would walk to a little cafeteria about a block from here. And I walked behind him because I was so concerned he would fall over. And we would go to lunch, and he would order the same thing, and we would come back to this courthouse, and his wife would pick him up. During that entire 2 years that I took him to lunch, he never said one word to me. He just came down here, I took him to lunch, we wouldn't talk, and he would leave. But I had so much respect for him that I thought that the least I could do in my life for him was to take him to lunch. That's all I did. Never sat on a court case with him, nothing. I said, the least I can do is take this man to lunch, because he, with Frank Johnson, had done so much that affected me, my family, my friends, and all of what you would call my people. And I thought that's the least homage I could pay to Judge Reeves. But anyway, Judge Reeves and Judge Johnson sat on Browder versus Gale together. And Judge Johnson tells the story of when they went back. And as you state judges know, you know about Plessy versus Ferguson, right? Well, Brown versus Board of Education had been decided. And the question was, does Brown versus Board of Education apply to public transportation? Now, hearing this case today, and you know, sometimes when you talk to lay people, they'll say to you, oh, your job is so easy. I know you hear that all. They don't realize that you sweat bullets a lot. And you're not always so sure that you've done the right thing, or that you're going to be upheld, or that you're going to be embarrassed in the newspaper because you've been reversed or whatever. But anyway, you might say that Browder versus Gale was an easy call. But think about it. Plessy versus Ferguson was on point to public transportation. The Supreme Court had already said that separate but equal was constitutional in Plessy versus Ferguson. So Judge Lynn, who dissented, said until the Supreme Court decides, we should follow Plessy and not Brown. Judge Johnson goes back into the conference room, and it says to Judge Reeves, and he's not certain what Judge Reeves is going to do. And he says to Judge Reeves, how do you go? And I think Judge Johnson was the youngest, so he would have spoken first, except he was a circuit judge. I'm not sure how it applied then, because Judge Lynn was a district judge. But anyway, Judge Johnson asked Judge Reeves, how is he going to vote? And Judge Reeves said, I think Brown so severely undermines Plessy versus Ferguson that we have to follow Brown. Judge Reeves dissents, relying on Plessy, saying it's on point. We don't have the authority to overrule Plessy. Judge Johnson and Judge Reeves vindicate Rosa Parks and declare it unconstitutional. Now, my little old case involving the use of deadly force, compared to that, which had national implications, they must have been sweating bullets. But that just shows the courage of these two men to do what they did, including Judge Reeves. I consider Judge Reeves sort of a hero that people just have not acknowledged just how great he was. In fact, I've started a little project of doing his history and letting people know that it was Judge Johnson, but it was Judge Johnson with Judge Reeves that achieved much of what happened in the state of Alabama, if not this country. But of course, as you know, they were eventually affirmed on appeal. Because it really was impossible to distinguish public transportation from the Brown language, which is what Judge Johnson said. Now, Judge Johnson, what happened to him? His mother's house was bombed. When I came back here in the 70s, he had protection everywhere. The governor of Alabama, said that what he deserved was a barbed wire enema. Of course, he received many, many threats. And yet he held the course. He stayed true to the course, even though his life was put in danger. So even with judicial independence, it still requires courage. You'll see I don't know if they'll show it to you later or not. There is a video of Judge Johnson. He's talking about, what does it mean to apply the law, what we call the rule of law, which I'm sure we all know what the rule of law is and how important that is. And you think it should be easy to apply the rule of law. And Judge Johnson says, it was an easy decision. I just applied the rule of law. And I think the commentator also asked him, what about losing all your friends? He said, I kept the ones that were worth keeping. I don't agree with Judge Johnson. I just think I think what he's saying is he just doesn't want to acknowledge himself just how courageous his acts were. And I think that just reflects the greatness of the man himself, is that he's humble. And you know, the old Shakespeare story, I'm trying to, I can't remember it. Anyway, it talks about having the strength of a giant. Measure for measure. I haven't told this before, but I'm pretty sure it's measure for measure. And they're talking about what greatness is. And it says it's great to have the strength of a giant, but don't sort of show it like a giant. Don't swagger it. And I think Judge Johnson was doing that. That's really greatness, when you can do these great things, when someone asks you about it, you're humble. And it's the combination of the two that in an ironic way reflect true greatness, when you don't brag about yourself. And I think in that film, he was confronted with great acts, but he put them off as everyday things. And there's also a second lesson there, which is everyday people really can do great things. And a really good judge, in just carrying out the rule of law, can do great things. And I think that's actually the message he's really trying to get across, that you don't have to be great to do great things. That you can be an ordinary person, and if you carry out the rule of law, it'll just happen. And I think that's really what he's saying. He's talking to other judges then, I think. He's saying, do your duty. Carry out the rule of law, and you will achieve anything that the law requires. Unfortunately, it does really require courage, too. You know, I've also found it remarkable that when we talk about Judge Johnson, that when you look at what he did, and we look at, you know, the way judges sometimes are viewed today, you know, people will say, oh, I'm a black judge, therefore I should rule for black people. Or you're a woman judge, therefore you should rule for women. I believe in a diverse bench, don't get me wrong. But I don't think you should rule for people just because you look like them. And I think if Judge Johnson stands for anything, he stands for the broader, bigger principle that you should rule for people who look like you, and you should rule for people who don't look like you. And that's a great judge. Judge Johnson wasn't black, yet he vindicated the rights of blacks. He wasn't a woman, yet he rendered great decisions about the rights of women. You know, I find it interesting that he was so sensitive to the rights of the mentally ill, because there was no man of greater intellect than Judge Johnson. And yet he was sensitive to the right of the mentally disabled. Or a prisoner. Oh my God, you should not have appeared in court if you were a defendant in a criminal case. He was going to be very, very harsh on you when it came to making sure that you complied with the law. He wasn't always sympathetic to defendants. But once you went to prison, he was equally as forceful in applying the Eighth Amendment. He says, I might give you a harsh sentence, but that does not mean that when you go to prison, you can violate the Eighth Amendment. I am not sending you to a sentence of horrendous conditions. I do respect your right to still retain your human dignity. So it's kind of funny, you know, all these things that come through all reflect the fact that he was able, I call it, to transcend himself. He was also one of the first judges to recognize the rights of gay people. And I heard some stories of people when he first, I think it was a dissent in a case, but he basically presaged Lawrence on the Supreme Court. He was a judge who grew up in Winston County, Alabama, who's sensitive to the rights of gay people. I just think that's just remarkable how he was able to follow what he viewed as the rule of law. And it arguably had nothing to do, in the sense of the people who appeared before him. He had no constituency as a judge. His constituency was the Constitution of the United States. That was the beginning, and that was the end. That was his constituency. So you always felt comfortable. I used to tell people that when I was growing up here in Alabama under Jim Crowism, this courthouse was the only place in the whole state of Alabama where I knew I could get justice, where I knew I would be respected, that I could have my humanity acknowledged. It was here, and it was in this courtroom. What a remarkable legacy of a man like that. In 1980, I was appointed to succeed him. I don't say replace him. All I can do is succeed him. There is no replacing him. But you can imagine how daunting that was. But it was truly an honor to be on the cases with him, to have had him help me along when he could, and now to be able to tell his story. And it's a story, as I started out, that starts when I'm 7 and 8 years old. Thank you very much.
Good job. Good job. Good job.
We have about 5 minutes. If I have any questions, anyone have any questions?
Oh, that's right. I forgot the question part.
Yeah.
Okay, good. No one had? I can't believe judges have no questions. Yeah.
Who paid for lunch?
You know, I'm not sure. I don't remember. You're a good judge. You know how to ask the question. I love it. I think we paid for each other's lunch, but Ms. Reed only had cornbread and aspic, but I probably cost 40 cents.
Have you presided over cases with Fred Gray?
No, I have presided over cases in the chief here before me.
Yes.
And Fred Gray, how many of you know who Fred Gray was? Fred Gray actually was nominated for the position I am now on. And I'd like to just take a moment and tell you about that. Fred Gray had represented Dr. King and Rosa Parks. In fact, when Rosa Parks was arrested, Clifford Durr and Fred Gray were her lawyers. And Fred Gray was appointed by Senator Huffman for the position. Was nominated by Senator, actually Carter, but you know, she's a senator who actually does it, and was nominated for the position behind the And his hearing came up, and it was a bloodbath. And eventually, he did not make it through. And at this point in time, when I really know the history of Alabama, there were, goodness, less than 10 black lawyers in the whole state. When I came back here in 1972, you know, I made number 11 or something like that. But none of the older lawyers wanted to go through what Fred Gray had gone through. And finally, Fred Gray agreed to withdraw his nomination, but only on the condition that I replace him. Fred Gray knew me before I knew myself. He knew my parents. He knew me as a little baby. So in fact, he made this announcement without even consulting me. To be candid with you, when I heard that Fred Gray had asked me to replace him, and the lawyers all came to me, including my senator, came to me and said, well, you know, you're the one who's to replace Fred Gray, I turned it down. Because I'd only been married a year, and I was 33 years old, and you know, I didn't want this job, the lifestyle of Judge Johnson. I did not want it, especially not being 33. It ended up that Carter was the president, and they were going to lose the judgeship unless I accepted. In the meantime, between when they approached me the first time and they came back the second time, I had talked to a very important person in my life, other than my wife. Now, who do you think could get me to do this if it wasn't my wife? I talked to my mom, right? And of course, she said very succinctly over the phone, you're an idiot, you do it. And I did. So I accepted, and one of the things I had a big issue was, getting back to it, was I was 33 years old. And it was a big issue. And there was really no one else who was willing to step up to the plate. And at the hearing, Senator Kaplan, who was my sponsor, tried to confront the issue of my age. And I had called some of my friends at Yale and said, what do I say about my age? An old professor named Charles Flaxey said, but just tell them that Justice Story, who was on the Supreme Court of the United States, was 32 when he was appointed. And all he wanted was a little district. So, I get into the hearing, and Senator Kaplan was just a wonderful Southerner. He was very, very courtly. He almost looked like a caricature of a Southerner. And he had a very slow accent, just talked very slowly. And he is introducing me. And of course, he knew the best way to deal with a difficult issue is to confront it head on. So he says by the way, there were only 3 senators there because they didn't have a quorum. They didn't have to vote me out unanimously, which they did. But anyway, there were 3 senators there. He's making a record. And of course, my family was up there and a few other people. And he says, I know you got a problem with Myron's age. But let me tell you, that's something that he can successfully work on and really every day. That's what everybody did when you did it. And it was over. No one brought up the age. I just thought that was so beautiful. What you do is if you got a problem, you make people laugh at it, and then it's not a problem anymore. Senator Kaplan was very gifted. Senator politician, he really was. He knew how to deal with the problem. Anyway, so Fred Gray, that's how I dealt initially with Fred Gray. Of course, he's appeared in this court, and he appeared on many cases here, including the Trooper case, where Judge Johnson ordered 1-for-1 hiring involving state troopers, which I later inherited, and ordered 1-for-1, one-time 1-for-1 promotions. Went to the Supreme Court, and I got affirmed in that. But that was an early Judge Johnson case, and that was an early Fred Gray.
Sterilization case, was that it also?
What do you mean, what organization?
The Tuskegee sterilization.
Yes, the Tuskegee sterilization was also this case. That is very, very true. It was here. That's right. That was actually resolved in the state senate. Yes.
Judge, you would be doing things like justice if you didn't tell them about your 5th grade teacher, her impact and
Well, it was actually, it was my, well, actually my
9th grade teacher.
And
I need to hear this.
30 seconds. When I was in the 9th grade, and I talked about teachers, and people ask me who had the greatest impact on my life, and I say my teacher did. And I have a feeling that's true for a lot of us. And literally, the teacher did. In the 9th grade, I went to the public schools. This is the first time I'd ever gone to an all-black segregated public school where the buses were hand-me-downs from whites, where we had no facilities, and it was just horrible. But anyway, the school basically had 2 tracks. They had a track for black kids who were going to college, and they had a track for black kids who were not going to college. Sounds pretty familiar. That's one of the things that doesn't change very much. It was all black, pretty much still exists in our society today. Schools for segregated. But anyway, I get to the 9th grade, and I had this teacher that I had been assigned to who was different. That is, she had me in her class along with all the other kids who had difficulty reading. And I considered myself an avid reader. And all of my friends who were
circles that I had grown up in Tuskegee were assigned to this other teacher. And I was literally angry with this teacher because I concluded that she had done this on purpose. That she had put me in my class with kids who literally were, sort of a year or two behind. And so I walked in with an attitude. And at one point, I just almost wouldn't talk to her. I was so angry. And of course, my other friends had gone to this other teacher who, they were all together, and they were reading things and so forth. Interesting things that I would want to read. And my teacher, first of all, took me and put me right in front of her desk. She gave me books to read at length. She would grade my papers, even if they were perfect ready. I mean, she just really held me to a level I had never been held before. She picked me up in the morning and she took me home at night. And I spent a year in her class. I told the story. I learned more from her during that 1 year in high school than I learned at Yale College or Yale Law School. This black teacher just literally took me under her wing and made me who I am today. When I said I write a perfect paper, I give all the right answers, but she would just go through it and say, think about this, think about that. And she just demanded everything from me, which shows what can happen when you have someone who cares about you and who demands the highest from you. So people ask me about who affected my 9th grade teacher who I absolutely hated. Because she literally changed my life. And I told the story about her, and to this day, I am so glad that she did what she did. To this day, I don't know why she did it, other than she must have thought the world of me. And I just am so thankful that she did it. Anyway, that's the thing. What? Oh, I would love it. No, she was wonderful. What was her name? Mrs. Perry, Corrine Perry. And another thing about Corrine Perry was, and I'm just going to talk about it like I put down where those can get it. When I was growing up in Tuskegee, you had on different sides of the track. Myron Thompson was on the other side of the track. And that house was kind of upset. So yeah, she was in for me, and she made me, to this day, I just, if she had lived to see me sworn in, she would have